Welcome to Tewary Immigration Law's Guide to the P-1A Athlete Visa. This visa category is a unique opportunity for athletes and coaches globally, allowing them to perform and showcase their talents in the United States temporarily. Whether you are an individual athlete, a member of a sports team, a professional athlete, or a coach, the P-1A classification provides a pathway to participate in high-level athletic events. Eligibility criteria for P-1A visa. Internationally recognized individual athletes. To qualify, you must be participating in a specific athletic competition in a sport where you are internationally recognized. This means you should have achieved a high level of skill and fame, with recognition in more than one country. Internationally recognized athletic teams. If you're part of a team, your team should have international acclaim in the sport, and the competition you're entering should be of a distinguished reputation. Professional athletes. Eligibility extends to athletes employed by a U.S.-based team, part of an association with significant collective revenues. This includes minor league teams affiliated with such associations. Amateur athletes or coaches. If you're part of a U.S.-based team or franchise and a member of a foreign league or association, you can apply under this classification. Theatrical ice skaters. Professional or amateur athletes performing in specific theatrical ice skating productions or tours are also eligible. Application process. Your U.S. employer, agent, or sponsor must file Form I-129, petition for a non-immigrant worker, along with the required fee and supporting documentation. This form is also used for extending your stay or changing your status to P-1A classification. If you have multiple employers while in the U.S., the agent filing Form I-129 must be authorized to act for all employers. Evidence submission. A written consultation from an appropriate labor organization. Copies of written contracts or summaries of oral agreements. An explanation of the events or activities, with dates and itineraries. Additional documents specific to your P-1A category. Internationally recognized individuals or teams. You must provide a contract with a major U.S. sports league or team and documentation proving your or your team's international recognition. Professional athletes. Evidence should include documentation of the team being a member of a qualifying league or association, and that the league's total combined revenues exceed $10 million per year. Amateur athletes or coaches. Submit evidence confirming your performance as part of a U.S.-based team in a foreign league meeting specific criteria. For theatrical ice skaters, provide proof of your participation in a specific ice skating production or tour. Family of P-1A non-immigrants. Your spouse and unmarried children under 21 can obtain P-4 status, allowing them to attend school or college in the U.S., but not to work. Essential support personnel. Support personnel, integral to the performance of a P-1 non-immigrant, can obtain P-1S classification. This includes coaches, scouts, trainers, and other necessary roles. After USCIS approves Form I-129, approved applicants can apply for a visa at a U.S. embassy or consulate. The period of stay varies, with individual athletes and their essential support personnel eligible for up to 5 years initially, and athletic groups and their support personnel up to 1 year. Extensions are possible under specific conditions. Change of employer. Professional P-1 athletes traded to a new organization have 30 days of continued employment authorization, during which the new organization must file a new Form I-129. For other changes in employment, a new Form I-129 is required before starting with a new employer. Understanding the application process and requirements is key to a successful P-1A athlete visa petition. For detailed guidance on your filing, contact Tewary Immigration Law.
If you would like Tewary Immigration Law's help on your immigration filing, please email us at info@tewary.com. Our attorneys are licensed in New Jersey and represent clients on immigration matters in all 50 states. This video is for informational purposes and should not be considered legal advice. Speak to an immigration attorney before applying this information to your specific case.